Welcome to the lecture on Chapter 1, Overview of Tort Law. Here we're going to sink our teeth into torts. Now, I wish we were sinking our teeth into what is pictured here on this slide. Unfortunately, this is not the type of tort we're talking about. This is a picture of a vanilla tort with the word ending in E. That means a cake. Unfortunately, we are not going to be talking about that, but instead we're going to be talking about the legal cause of action called a tort, T-O-R-T. So let's get started with some basic terms in tort law that you're going to need to know throughout the rest of the course. The term tort comes from a French word meaning wrong. And in our legal system, a tort is a civil wrong other than a breach of contract for which the victim usually receives a remedy in the form of money damages, normally to compensate the victim for the harm caused by the wrong. Now, focus especially on the term civil. Torts are not crimes. They are instead part of our civil law system, which involves private lawsuits by private individuals against the person or entity that harmed them, seeking compensation. These do not involve criminal prosecutions. Now, the person who commits a tort is not a criminal because, again, torts are not crimes. Instead, the legal term for such a person is tortfeasor. Now, if an act or practice has the characteristic of a civil wrong, then it is called tortious, T-O-R-T-I-O-U-S. Notice that it is not tortuous. Your spell check on Word may not catch this, but tortuous means meandering or winding or twisting, but tortious is the term meaning having the characteristics of a tort or being tort-like. Now, as we will see throughout the course, there are three basic categories of torts. The first category that we'll study this semester is the intentional torts. And those are civil wrongs, again, not crimes, but they are nevertheless committed with some form of intent or other wrongful mental state, like knowing wrongs or reckless wrongs. The second category, and the one we will be spending the most time on because it's the most common of the torts that you see in litigation, is negligence. Now, negligence is a civil wrong committed without any form of intent or other wrongful mental state, but instead it is a wrong that is committed when a person violates a standard of care imposed by law. Now, as we will see later in the course, the most common standard of care imposed by negligence law is the duty to exercise reasonable care under the circumstances. And so if a person owes a duty toward others in the same circumstance to exercise reasonable care, or another way of putting it, to act as an ordinary prudent person, then a person will commit negligence if that person violates that duty of care and acts unreasonably or fails to act as an ordinary prudent person would under the same or similar circumstances. So negligence involves a violation of a standard of care imposed by law, not any form of blameworthy or culpable mental state. Now, finally, the other big category of torts that we'll look at this semester is strict liability torts. Those are torts that consist of an act or omission committed without any kind of intent or other blameworthy mental state and without violating necessarily a legal standard of care, the way you would have to do to have a negligence tort. And these are certain types of torts that the law, as a matter of public policy, treats as civil wrongs, even though they don't involve some form of intent or some actual violation of a legal standard of care, and would allow the person harmed by the act or omission to be able to recover against the tortfeasor anyway. As we will see, product liability cases are a very common situation where strict liability will be imposed. So these three torts will set up the bulk of the course that we'll be looking at throughout the semester, and especially the category of negligence. Now, tort law comes primarily from a state's case law. There are torts that are recognized under federal statutes, but primarily tort law is governed by state law, and it is primarily case law or common law. That is case by case decision making by courts, laws that are judge made laws that are articulated in the decisions that courts make on individual cases. Now, there are sometimes some state statutes that do govern torts. Uh, they don't they don't dominate tort law, but they are there, and we will be looking at some of those this semester. One of them is the wrongful death and survival statutes that all states have, including Texas, and criminal statutes, even though they do not form the basis of torts, because torts aren't crimes. Criminal statutes, as we will see, sometimes act as guides to public policy in enabling courts to decide what would be the standard of care in tort law that a particular person would owe to another. For example, criminal statutes governing DUIs or driving under the influence of alcohol or other drugs can indicate the blood alcohol level above which a driver would breach his or her duty of care in a civil tort action. Now, the secondary sources that are most applicable in tort law include the Restatement of Law of Torts published by the American Law Institute. This is essentially an outline summary of all of the aspects of tort law as compiled from the tort laws of all the states in the country. And the American Law Institute is composed of many very well-respected law professors, jurists, and other legal experts. And they have tried to summarize all of the principles of tort law in a systematic, organized way, focusing mainly on the black letter principles of tort law, also known as black letter law. That is, those principles of tort law that are generally accepted by the legal community and tend not to be that controversial. However, where states have disagreed on certain principles, the Restatement of the Law of Torts will set forth the American Law Institute's opinion as to what that body believes the law should be. Now, despite these black letter principles, tort law will vary from state to state. So you would need to be sure whenever you're doing research that you research the law of the particular state that will govern your issue. Now, attorneys and courts frequently cite the Restatement of Torts as persuasive authority on a legal topic. And courts, in fact, if a court agrees with a restatement position, the court can expressly adopt a restatement position as the official law in the state. So, restatement of the law of torts is a very weighty and well-respected secondary source of law, particularly when you cannot find a primary source of law, such as a court decision, that addresses your specific tort issue. Because torts often involve the violation of a standard of care, whenever courts or any other lawmaking bodies like legislatures are trying to determine what the law should permit or what the law should prohibit a person from doing, courts are always going to be concerned with whether their decisions, if appropriate in one case, will nevertheless have negative unintended consequences in future cases. And this concern of being able to articulate a standard of care that, while appropriate in the case that the court is currently deciding, will not have unintended negative consequences for the law and legal system later on, is often described by one of three different metaphors. And the first one is courts and legislatures are often afraid of, quote, opening the floodgates to tons of litigation if they permit recovery on the basis of some standard that is too broad. Another metaphor is courts are afraid that by ruling and permitting recovery in one situation, that logically people in slightly different situations will be able to use their same argument for recovering until you finally keep slipping down the slope to allowing recovery for actions or breaches of standards that were never intentionally intended. That's the sliding down the slippery slope argument. And then finally, the way courts try to avoid opening the floodgates or sliding down the slippery slope is often referred to as drawing the line. Where do you draw the line between the behavior that should give rise to tort liability and the behavior that should not, for example? So let's look a little bit more detail at these three metaphors. You will see these metaphors throughout your legal career, because in making arguments to courts, courts are going to be very concerned about whether your particular argument or your supervising attorney's argument will have the unintended effect of, for example, opening the floodgates. So here's a picture of floodgates. As you can see, when the gates are open in a river or stream or canal, then of course water floods out. And so that is why this metaphor is so apt for the concern of courts, that they decide a particular case in a way that it sets a precedent uh, that will not open the floodgates for so many lawsuits to follow that it will overwhelm the court system and be too broadly interpreted beyond its original purpose. So one common way that the floodgates can be opened is allowing for the first time a plaintiff to recover for a particular kind of injury. And so the courts are concerned with the basic principle that not all human wrong can be remedied in the legal system. We undergo irritations, insults. We can be jilted by significant others. We can be experience things we don't like, but not everything we experience that we don't like is or necessarily should be something that we could recover for in a court of law or in a court of equity. And so it is this idea that not all human wrong can be remedied that underlies courts' concerns about opening the floodgates. Now, a related argument to opening the floodgates is the slippery slope argument. Now, that is an argument that that has the unintended consequence of setting forth a set of reasoning or logic that, though applicable and appropriate in the case that the court's currently considering, may unintendedly be used by later litigants to recover for types of injuries or under circumstances that were not originally intended in the first case. And so but the logic is such that because there is no logical line to be drawn, that future litigants can seize on that logic and reasoning process to expand the scope of recovery or liability beyond its original intent. So when you have judges making rulings on what conduct should give rise to tort liability, or what types of injuries and harm should be recoverable by a plaintiff in a tort case, the courts are very concerned to achieve two goals at the same time. First, to achieve a fair and just resolution to the specific dispute between the parties in that specific case, and at the same time, achieving a decision that will not set a precedent that could be applied to achieve less desirable or less just results in future cases. So here is the slippery slope in a graphic illustration of the concept. Here you have the first court decision. You're at the top of the slope. You're like a skier. The first court decision rules that a certain behavior will give rise to tort liability, and or a certain type of harm is recoverable under tort law. And in that particular case, it results in a very desirable, fair, just outcome for the parties involved. But that case can set a precedent where down the road or down the slope, different parties will seize on that first case as a basis for arguing that the recovery should be expanded, or that the standard of care should be applied more broadly or in different circumstances, and give rise to liability or recovery that may be less desirable from the point of view of the law than it was in the first decision. And then that second decision, in turn, could be used as a precedent for later litigants to expand the scope of this particular recovery or application of a legal standard in even less desirable circumstances with even worse outcomes. And so it just keeps going on. Once you're on the slippery slope, you can't stop. There's no logical cutoff. And so the end result of a slippery slope, and it's what courts are trying to avoid, and legislatures also, is finally having a morass of undesirable outcomes that all flowed from the first court decision, because it was worded or articulated in such a way as to not provide a logical line or stopping point. It just put everything on a slope, and ended in a totality of undesirable outcomes. Let's look at a specific example of this, and on an issue that has been very controversial in this country, and that is physician-assisted suicide. Now, I'm going to use the same graphics to illustrate how particularly opponents of physician-assisted suicide, or at least those who want to keep physician-assisted suicide limited to certain circumstances, how they fear that court rulings can lead to the slippery slope phenomenon. First of all, you may have a court that has a seminal decision saying that, ruling that a physician-assisted suicide is permissible under the law if a patient is terminally ill. And we're using this hypothetically. Some states do allow physician-assisted suicide, others do not. But purely for the sake of illustrating the slippery slope argument, let's say that you have a court that rules that a law permitting physician-assisted suicide is constitutional and enforceable when a patient is terminally ill. Now, that may have created a fair and just result in that case, depending on your perspective. But later, you might have parties challenging a law and using the first court decision as the precedent to extend that reasoning, not only when the patient is terminally ill, but if the patient is suffering extreme physical pain, and to such an extent that even though the patient is not terminally ill, the physical condition is such that physician-assisted suicide should be permitted. Now, if you have a second court that agrees with that argument, well, then that in turn can create the precedent for future parties to come in and try to extend the reasoning, not only to patients who are terminally ill and patients who are suffering great physical pain that is, not treatable, but also to extend it to patients who are suffering mentally, not necessarily physically, not necessarily terminally ill, but suffering such mental pain and mental distress that cannot be treated, that physician-assisted suicide should be extended to allow to occur in that circumstance as well. And so the fear of people who or in courts who are afraid of letting this get out of control is that ultimately where this might lead is that physician assisted suicide would be permissible and ruled permissible whenever a patient requests it or demands it. And so this is an example, regardless of your position on physician assisted suicide, this is just an example of how courts might look at the potential future impact of their ruling if they allow and if they permit physician assisted suicide in one situation. Would it in fact put the courts on a slippery slope to having to allow it in broader and broader circumstances, ultimately perhaps even resulting in simply whenever a patient wants it? Now, the final metaphor is drawing the line. And drawing the line is the way courts and legislatures attempt to avoid opening the floodgates and avoiding the slippery slope problem by articulating boundaries and limitations to their holdings or rulings on the issues in the case so that they won't be applied too broadly in the future. And again, this is one of the most difficult things to do when articulating legal standards. Again, it's a difficult balancing act to to articulate a legal standard that is fair and has desirable outcomes while keeping it sufficiently limited to avoid it being used for undesirable outcomes in the future. It's a very tricky and difficult thing to do. And so both the courts and the legislatures want their rulings to be broad enough to yield the desirable society outcomes, but narrow enough to prevent undesirable outcomes. And so here you have a picture of a girl drawing a line in a sand. And on the left side, we have the desirable outcomes. And what courts do is what the girl's doing. They try to articulate the standards in such a way that there is a discernible boundary or limit to the outcomes that can flow from that particular ruling. And so, in other words, that's where the slope would stop, is at that line. Now let's look at how tort law compares to certain other areas of the law. There are two other areas of the law that you need to understand how they are similar and how they are different from torts, because in some ways they overlap. Let's first look at how torts compare to crimes. Now, torts, when we talk about torts, the civil cause of action of a tort, the interest that has been violated, and thus is the basis of the suit, is the individual victims, the person who is harmed by the wrong. That is the interest that's been violated. Now, it's different with crimes. Crimes are criminal wrongs that are defined by statute, the Texas Penal Code, for example, and are seen not just as a violation of an individual person's or the victim's interest, but society's interest. Society has an interest in not having people being murdered. Society has an interest in not having thefts and robberies occur. So the interest violated in tort law is the individual victim's interest, whereas in criminal law, the interest violated is the interest of society as a whole. And you will note that in tort lawsuits in civil courts, it is the individual victim who files the lawsuit seeking compensation against the tortfeasor. Whereas in criminal prosecutions, it is the state represented by the district attorney or the United States attorney in federal criminal cases who are representing the state, that is the society at large, in bringing charges and seeking to obtain a conviction for a criminal offense. Now, the purpose of tort law is primarily to compensate the victim so that, as closely as possible, the victim can be put back in the position the victim would have been in had the tort not occurred, such as payment of money damages to compensate for medical bills, to compensate for pain and suffering, to compensate for the cost to repair or replace property that has been damaged. Now, by contrast, the primary purpose of criminal law is to punish the wrongdoer. So, as we'll see, there's some overlap, but primarily criminal law is interested in punishing the wrongdoer, and tort law is interested in compensating the victim. Now, the applicable procedural rules in tort lawsuits, because they are filed in civil courts, they're not criminal matters, the applicable rules of civil procedure will govern the procedure, such as the Texas rules of civil procedure or the federal rules of civil procedure. But in criminal cases, the procedure is governed by the rules or code of criminal procedure, such as the Texas Code of Criminal Procedure. Now, torts being civil matters require the plaintiff at trial to prove the elements of the tort by a preponderance of the evidence. That is, the plaintiff must prove each element of the tort, such as negligence, and to a standard that the jury must be able to find that each element is more probable to be true than not. It is simply a balancing. And if it is 51% more probable that all of those elements are true, then the jury should find for the plaintiff. Now, in criminal cases, the standard is much higher for the prosecution or the state. The prosecution or state must prove the elements of the crime beyond a reasonable doubt. That is a far higher standard to meet. That means each element of the crime must be proved to be almost absolutely certain to be true. And that, again, is a far higher burden of proof. So this is where torts and crimes differ in many respects. Now, let's look at where they can actually overlap, how tort law and criminal law actually, in small areas, can overlap with each other. Let's look at the purpose of the law. Tort law, as we saw, is primarily concerned with compensating the victim for the harm caused by the tortfeasor. But, as we will see, in tort law, if the defendant has engaged in especially bad behavior, even again, such as fraud or committing a tort with malice or with gross negligence, then the plaintiff may recover not only compensatory damages, but possibly punitive damages, also known as exemplary damages. And punitive damages are damages over and above what would compensate the victim for the harm and are designed to punish the tortfeasor. And so here you have tort law in this punitive damages aspect overlapping with the purpose that is normally the realm of criminal law. Now, similarly, in criminal law, the main purpose is to punish the wrongdoer, but courts frequently order that the convicted criminal pay restitution to the victim to compensate the victim for the harm caused by the crime. And restitution is often part of the sentence imposed on the wrongdoer. So here you have criminal law overlapping a little bit with what is normally the tort law purpose of compensating the victim. Now, the burden of proof uh, in tort law and criminal law, in very limited circumstances, can sometimes overlap. As we saw, the burden of proof that the plaintiff has in a civil tort case is preponderance of the evidence. But there is a intermediate standard of proof that is halfway between preponderance of the evidence as the lightest burden of proof and beyond a reasonable doubt, which is the hardest burden of proof, and that is called clear and convincing evidence. And in certain tort actions, in certain circumstances, the plaintiff will have to prove the relevant facts by clear and convincing evidence instead of the normal preponderance of evidence. And oftentimes this applies when the plaintiff is alleging fraud, or some other ground, especially for obtaining punitive damages. And in certain limited circumstances in criminal law, the prosecution will have to prove certain facts by clear and convincing evidence as well. So here you have a little bit of an overlap. It's very limited between tort law and criminal law when clear and convincing evidence is the applicable standard. But again, primarily in civil law generally and in tort law also, the basic standard is preponderance of the evidence. Now, some actions can constitute both a tort and a crime. For example, you might have a driver who's drunk and drives and hurts someone, and that injured person can sue the driver for tort, be like negligence or gross negligence, and get to get compensation. Well, of course, if the driver was driving intoxicated, then the driver may also be charged with the crime of driving under the influence or driving while intoxicated. So sometimes you will have an act that will constitute violation of both tort law and violation of criminal law. So that's a comparison of torts and criminal law. Now let's look at how tort law compares to contract law. Now, for torts and contracts, they're both civil cases. They're not criminal matters, but they have certain key differences. First of all, in tort law, the duties owed by the person who winds up breaching those duties and thereby subjecting himself or herself to tort liability is the tort laws themselves. Tort law, the law of that's, for example, Texas tort law says that if you're going to drive a motor vehicle on public roadways in Texas, then you have to operate that vehicle using reasonable care under the circumstances. It's imposed by law. It doesn't matter whether the driver or anybody else around them agrees to that law or consents to comply with that law. The law is what it is, and it has to be followed. And if you don't follow it and you cause harm, then you could be sued and have to compensate the victim. Now, in contract law, the source of the duties owed by the parties is different. It's not imposed by the law on all residents of the state uniformly like tort law. Instead, the parties voluntarily enter into agreements between each other, and they voluntarily obligate themselves to do certain things as part of the contract. And so the source of the duties owed is with the parties' consent in a contractual matter, whereas in tort law, it's without the parties' consent. Now, in tort law, these duties are owed to all persons in the same or similar circumstances. So if you are driving a motor vehicle on a road in Texas, a public road in Texas, then you owe that duty of reasonable care, or the duty to act as an ordinary prudent person, toward all of the persons in the same or similar circumstances, to all other drivers or all other pedestrians or all other property owners in the vicinity. Whereas in contracts, the duties are only owed to the other parties to the contract. So again, it's a much more limited scope of to whom the duties are owed. Now, the remedy for violation of these duties in tort law, as we've seen, is usually to compensate the person harmed, to put that person back in the position he or she would have occupied had the tortfeasor not committed the tort. And in certain circumstances, to punish the tortfeasor with punitive damages. Now, in contract law, it is also to compensate the non-breaching party or the innocent party for damages resulting from the breach of contract, but it is to place that person, that innocent party, in the position she would have occupied had the breach of contract not occurred. In other words, the position he or she would have had if the other party to the contract had actually done what that person agreed to do and the contract had been fulfilled according to its terms. And that's the way it's calculated in contract law. But in tort law, the idea is to simply put the victim in the position he or she would have occupied had the wrongdoing never occurred. Now, tort and contract law sometimes do overlap, and here is the way that can happen. In tort law, sometimes the law actually does impose certain duties that are tort-related duties in connection with a contract. For example, you may have a contract with an insurance company that is an insurance policy, but the law of Texas and common law says if an insurance company has a claim for some kind of damages made against it, like you had your car was hail damaged or your house was hail damaged, then that insurance company owes a common law tort duty to treat its policyholders with good faith and in fair dealing. So that is a sort of an additional duty in tort that arises in certain types of contracts. The contract doesn't have to say this. Tort law imposes that duty anyway. Now, also, sometimes when you have a contract, there may be some duties that a party assumes under the contract terms that actually may coincide with tort duties. And so again, here you have, if you have a contract, for example, with an insurance company, and that contract says we, the insurance company, agree to treat the insured or policyholder with good faith and in fair dealing, that contract is simply restating the law, the duties that are already imposed by tort law on an insurance company in that situation. So there are certain narrow circumstances where torts and contracts can overlap. There are also torts that relate to contracts, such as the tortious interference with a contract is one of them. And there are certain torts that involve bad faith breach of contract, such as when a person enters into a contract with absolutely no intention of ever performing it. So there are some other areas of overlap as well. Okay, let's round off our discussion and overview of tort law by looking at how it originated. Now, as much of our laws have in the US have originated, um, the history of tort law goes back to Anglo-Saxon culture in England. In Anglo-Saxon culture, if any outsider of a particular clan inflicted harm on a clan member, then the entire clan of the afflicted member would go to war against the outsider or the outsider's clan for revenge for the humiliation suffered by the family members or kin of the victim. So it was seen as a clan by clan affair. So, and in fact, in the U.S. In the late 19th century, a feud of sort arose between the Hatfield family and the McCoy family of West Virginia. And it all began to arise with a dispute over a hog, and it mushroomed into this legendary feud between the two families. And so this feud was called a blood feud because it would involve a clan going and literally attacking physically the people in the other clan to get revenge. Now, early on, people in Anglo-Saxon England tried to avert this blood feud, or at least minimize its occurrence by creating an early form of alternative dispute resolution called the moot, M-O-O-T. And in the moot, the victim could uh, have access to a forum of the community in which the victim would summon the perpetrator to appear. And the victim would plead his case to the community, explaining what the victim did wrong and how he was harmed, and then ask for some form of redress of his grievance. And then in response, the community members would have input about how they thought it would be best to resolve the dispute. So if the victim and perpetrator could arrive at a mutually acceptable solution, then the parties would disperse and the blood feud would not occur. Now, over time in these moots, the people began to develop a collection of principles and rules that they would start to apply again and again in similar cases because they learned that these principles and rules tended to work especially well in resolving the disputes. For example, rather than having the one clan go engage in a blood feud against another, instead, they might have the perpetrator pay a certain amount of money or something else of value, like livestock or crops, to the victim to compensate the victim and replace the blood feud. Now, that, of course, would become very common and a staple of tort law in later years. Now, at this early stage, though, generally there was no concern regarding fault or blameworthiness, no concern about whether it was done intentionally or not, and no concern with whether it uh, reached any standard of care. Rather, it was pretty much a strict liability situation. Now, after the Norman conquest of 1066, this dispute resolution was taken out of the hands of the communities and fell to royal justices of the king's courts. But these justices discovered that if they would apply the already common and traditional rules and principles that had previously been applied, that they could resolve conflicts more efficiently. So what these justices would do is they would articulate in case-by-case court decisions these rules and principles, and they would apply them in reaching the decisions in the cases. And so these rules and principles, they began to build up in these written court decisions, and it is these court decisions with their rules and principles that evolved into what's now known as the common law. Now, it was called common law because it was set down to apply commonly throughout the entire realm of England. So the earliest common law were the rules articulated in court decisions and applied by the king's justices uniformly throughout the country. So you didn't have one community applying one set of rules and another community applying a different set of rules to the same types of disputes. It helped make uniform the application of the laws in the realm. Now, as common law evolved, the circumstances under which a person could sue in court began to become more defined. And they began to be divided into very specifically defined causes of action, or sometimes just called causes, or sometimes just called actions. Now, a cause of action, and this is a definition that will apply today, is a recognized legal theory for a person to sue another in court and recover from that person that is also supported by sufficient facts of the particular circumstances to justify suing under that theory. So that's what a cause of action is. To sue, you have to have one. You can't just go in and complain about anything. You have to have a recognized legal theory of recovery that the law recognizes and is set forth in the law, plus the facts of your particular dispute have to support that theory. Now, one of the earliest causes of action back in England was the action in trespass. Now, this was a cause of action that arose when the tortfeasor used force directly on the plaintiff's person or property, on the person's body, for example, such as if they hit the plaintiff or destroyed the plaintiff's property. There was a Latin term that normally went along with this cause of action called vi et armis, which means with force and arms. And that phrase appeared in every court order of trespass as a matter of course. Now, in an action in trespass, if there was direct force on the plaintiff's person or property, then the plaintiff didn't have to prove any fault. And when I say fault, I mean either wrongful intent on the part of the tortfeasor or any violation of a standard of care, such as to act reasonably. That's what fault is, either wrongful intent or mental state, or a violation of some recognized legal standard of care. Well, in an action of trespass, the plaintiff did not have to prove fault. If there was direct force, then that's all that was necessary. And in fact, the plaintiff didn't even have to prove that the plaintiff was actually harmed or that there was actual damage of any kind. If there was direct force on the plaintiff's body or property, then harm was presumed, and the plaintiff didn't even have to prove it. So now, this cause of action in trespass was so narrow that it precluded recovery by those who were harmed by someone's actions, but that tortfeasor had not used force, or that person had indirectly used force and had or indirectly caused some kind of harm to the plaintiff. So because of this limitation on the action in trespass, a new cause of action developed called trespass on the case. Now, in a trespass on the case cause of action, the defendant was accused of causing injury, but without force, without vi et armis. This would have been without force, indirectly, or maybe just negligently. So, for example, if you had someone who entrusted his or her horse to another, and that other lost the horse, here you have harm, but it was not caused by direct force. It might have been just by the carelessness of the person to whom the horse was entrusted. So in a trespass on the case, the plaintiff could sue that person alleging that there was injury, even though it was without force. But in a trespass on the case, the plaintiff did have to prove fault, either wrongful intent or violation of standard of care. So if the person intentionally lost the plaintiff's horse, or if the person was negligent, didn't take reasonable care in keeping the horse, then that would be an example of fault that the plaintiff would have to prove to recover. And then finally, in trespass on the case, the plaintiff had to prove actual harm or damage. It was not presumed. So here, unlike in the old trespass on the case, on the action in trespass, the trespass on the case required a showing of fault and a showing of actual harm or damage. Now, these two causes of action trucked along in the legal systems in both the England and in the United States until a crisis occurred in the law, and it coincided with the development of the automobile. And here is the problem. As transportation developed, the old action in trespass became a real problem. Every accident involving cars involved direct force because the cars would hit each other or a car would hit a pedestrian. Well, if it involved direct force, then it qualified as an action in trespass. Well, the problem is if it qualified as an action in trespass, then the plaintiff did not have to prove fault. It could have been a totally innocent mistake. It could have been the person driving the car may have been extremely over the top careful, but the accident still occurred and that person would still be liable. So, and also the plaintiff didn't have to prove harm. But if the plaintiff did prove harm, then a single accident could automatically cause the driver to lose all his money. So this was a real problem, the way these two causes of action had been set up in prior pre-automobile days. So the law developed a compromise between the old action in trespass and the trespass on the case. And this compromise was the idea of the negligence cause of action. In other words, under the negligence cause of action, even though a car accident involves direct force, vi et armis, a driver will not be liable for causing the accident as long as the driver drove with reasonable care, or in Texas, we would call it ordinary prudence, to reduce the risk of accidents. And so the plaintiff would have to show that the driver had not driven with reasonable care or with ordinary prudence in order to recover. So, like the action in trespass, negligence can be asserted when the defendant committed direct force. If there's a car accident and your car is hit by another, that's direct force. That's vi et armis, and so you can bring a negligence cause of action. But like the trespass on the case, in that situation, you would have to prove both fault on the part of the defendant, that is, that the defendant failed to exercise the required degree of care, usually to act reasonably, and you would have to prove actual damages caused by the defendant's conduct, such as personal injuries, the damage to your car or other property. So negligence finally came of its own as transportation technology advanced in this country. So here is the basic overview and landscape of the modern negligence cause of action. I want to look at the same three elements that we looked at in connection with the old action in trespass and trespass on the case. First of all, the nature of the wrong for negligence is that the defendant failed to follow a required standard of care, a duty of care that the law imposes on the defendant under the particular circumstances, and that care is normally described as the duty to exercise reasonable care under the circumstances, or to act as an ordinary prudent person under the circumstances. But as we've just seen, the plaintiff also has to prove fault. Now, fault in this case would be violation of the standard of care. And finally, the plaintiff would have to prove actual harm or damage. In negligence cases, the law does not presume any harm or damage from the breach of the duty of care. The plaintiff has to prove that he or she suffered some kind of injury or other harm as a result of the negligence. Now, that is the history of negligence. Again, it is a fault-based tort. You have to show breach of the duty of care, as well as proving actual damages. Now, this fault theory of tort came to the high watermark of it was in the 19th century when, after the Civil War, many intellectuals who were influenced by the Industrial Revolution wanted to take a scientific approach to how justice can be served in civil tort cases. Now, among these scholars who took this scientific approach was a U.S. Supreme Court justice named Oliver Wendell Holmes. And he scientifically observed and cataloged common principles for determining how to create fair and just results between the individual parties to the dispute. And so it is in this context that these jurists created and articulated the general duty of care that resulted in this fault theory of tort. That is, either requiring a wrongful intent or other wrongful mental state, or violation of a legal duty of care, such as to act reasonably under the circumstances. So this idea of requiring a showing of fault, either intent or some kind of negligence or failing to act reasonably, was the product of the 19th century legal landscape. Um, and Oliver Wendell Holmes was one of the great luminaries of that time. Now, there was soon thereafter, in the early 20th century, a reaction against this scientific approach to trying to achieve a fair result just between the parties to that one dispute. And intellectuals in the beginning of the 20th century began to look at society as a whole and see poverty and social disadvantage. And they began to see this not as the problems of the individual parties involved, but rather as systemic societal problems. Now, among these intellectuals in the 20th century was law professor William Prosser. And he, along with other scholars, saw themselves as revolutionaries who wanted to strive for rules that equitably distributed losses to make society as a whole more just, and not just seek a fair result between the two parties in a lawsuit. So what they lobbied for was the adoption of what we've seen as the third big category of torts: strict liability torts, particularly with respect to harm that was caused by defective products like vehicles or electronics. Their idea was that liability should not always necessarily be predicated on some finding of actual fault, but especially when you have a manufacturer or retailers that put products into society that spread throughout society, you should impose liability in that circumstance where the manufacturer or retailer is in the best position to pay that liability. And so the idea was that if you have someone who is injured by, say, a defective toaster, then it is far easier for the manufacturers of the toasters to pay the injuries, regardless of whether they breached a duty of care or not, as long as their product was defective. It's easier for them to raise the price of their toasters by 1 cent. They could recoup the cost of their liability almost without even noticing it. Whereas an individual who would have to sue and prove that the toaster had been negligently manufactured or negligently designed or negligently marketed would have a hugely high burden. And if that person lost, then it would be a far greater burden for that person to bear the medical expenses. And so this was part of the thinking among these 20th century legal realists who began to look at the impact of liability on society as a whole, and believed that liability should be borne by those who are best able to bear that liability. That is usually the manufacturer in product defect cases. So that brings us sort of full circle. We came from the early action on the trespass, action in trespass, where if it was direct force used, it was essentially strict liability. You didn't have to prove fault, and you didn't have to show actual damages. Well, now in the 20th century, when product liability and strict liability law uh, occurred and arose, then you had a development in the law that was more strict liability, and you had a full circle in the in the development. Now, as we will look at toward the very end of the course, tort reform is a huge issue, and it's fraught with controversy. But legislators and courts have been wrestling with these ideas that we've looked at over the last few minutes about what is fair. Should, what, under what circumstances is it fair to impose liability without fault? Is that fair actually to manufacturers? Or would not permitting strict liability be unfair to consumers, individuals? And so, and when can tort liability, particularly with punitive damages, run so amok that it could actually harm society, because society uh, uh, will find itself with manufacturers and others that are too afraid to innovate, too afraid to put products on the market for fear that they will be hit with lots of lawsuits. And so this is a big debate, and the concept of tort reform is an ongoing debate. Should society bear the costs of losses suffered by individuals, or should that responsibility be shifted to the individuals themselves? What role should fault, such as intent or breaching a standard of care, play in tort law? Should it always be there, or are there circumstances where a plaintiff should not have to prove fault? And is the purpose of tort law merely to resolve the disputes between the actual parties involved, or does it have a broader purpose to see that justice is done on a society-wide scale? These are all issues that we'll be looking at later in the course, but I hope this gives you a nice foundation, and I hope that it inspires you and encourages you as we begin our journey in tort law. And we'll be looking next at an overview of an actual tort lawsuit. So thank you for listening.